Joining me now for more on this, white-collar defense lawyer Seth Berenzweig, former Trump attorney and CNN legal commentator Tim Parlatore, and CNN legal analyst and former prosecutor Karen Agnifilo. Seth, let me start with you first. Do you think this appeal will be successful? What do you make of Trump being in court?
It's going to be an uphill battle, and I think it's important to kind of zoom out along the lines that were mentioned a moment ago. It's unusual in civil trials to have an appeal where the defense didn't put on any evidence, any rebuttal witness. Very, very unusual. We're going to be hearing about specific evidentiary arguments today, specifically with respect to the Access Hollywood tape and how that came out during the use of a deposition excerpt for Mr. Trump, as well as other witnesses, two other ladies that had accused Mr. Trump of similar conduct. And given the fact that it is a federal appellate case, it will go under advisement to the bench. We will not hear anything this year. We won't hear anything before the first quarter of next year. So a lot of fireworks today, not much happening after that prior to the federal election.
And Tim, as we've been saying, he's not going to be allowed to speak today. He is going to have this news conference or press conference, whatever they're calling it, at Trump Tower in a few hours from now. Is he trying to go back to that playbook that we saw during the Republican primaries where he would go to the courthouse, put on a big show? Does he think there's a political benefit to all of this? Would you advise him to be even down there today?
Well, you know, for an appeal, I generally don't have my clients go unless they want to go for the entertainment value, because it's not something that, appeals are very different from trial. And the judges are looking directly at the lawyer and asking a lot of pointed questions to the lawyer. So I don't think it makes any difference that he's there, but I do know that he is, upset at how that trial went, and I think that he probably regrets not having been there and the way that first trial was handled. So I do think that he has kind of a personal interest in getting up there to watch this because of that history. Is it going to make a difference in the case? No, not at all.
I was going to say, because you've been with him before, does he think that being in the courtroom in front of the judge somehow affects the outcome? He'll get a more favorable outcome if he's there, sort of, his presence is there and so on?
I don't think that he necessarily thinks that so much as that first trial. He wanted to be there. He should have been there. That case was handled by a lawyer who's no longer with his team, and and he can't really claim ineffective assistance of counsel because it's a civil case. And so I think that really is playing into he wants to show that he's involved in this case.
Yeah, and Seth, I mean, your sense of whether you would have a client in the courtroom for something like this.
Well,
as Tim was saying, you would purely be there for entertainment purposes, which obviously, you can insert your own comment there. But
well, ordinarily in a federal appeals case, usually but not always, you have your client appear, especially in civil and business litigation. So that aspect is not unusual. Of course, we have Mr. Trump there, who really knows how to run the circus, so to speak. So that's an unusual feature. But the thing that is so fascinating to me, handling a lot of federal civil litigation, is that the arguments today are going to be talking about the weight and the admission of certain evidence. Well, it's hard to argue with the score when you don't put your players out on the field. Since they didn't have any witnesses in the case, the balance of evidence is going to ultimately also go to whether any error constitutes reversible error. Remember, with the witnesses that were brought on in the case to talk about whether he engaged in kind of a pattern, if Team Trump knew how to handle discovery in civil litigation case, they would have, at a minimum, taken a couple of depositions of video by a couple of female colleagues that they could play as deposition excerpts during the trial to be able to rebut that pattern evidence. That's basic federal litigation 101. They didn't even do that. So this is pretty unusual in a few different dimensions.
We'll see what happens. All right, guys, thank you very much. Really appreciate it.